The first case to come before us is Zola Properties LLC versus Reed Salvage Corp. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument if that applies. You can refer to them by initials or terms like the child. We've read your briefs and are prepared to proceed when you are.
Good morning. I'm Ted Lesiak, and I represent the appellants, Zola Properties LLC, who is the owner of what we'll call the Zola property, Oscar's Party Center LLC, and Bella's Creamery LLC, who are the tenants of the Zola property. I would like to reserve 5 minutes for rebuttal. And as Judge Lanziger has said, you've read the briefs. The layout of the property here is a little difficult. Basically, we have a property that was divided into 3 properties. One is not part of this argument. We'll call the Zola property the northern property, the Reed property that was part of the division, the southern property, and then Reed, the appellee Reed, Salvage Corp owns another property that is to the east of both the northern and southern property. Okay, this is about the court's granting the summary judgment regarding an implied easement to Reed Salvage Corporation. Now, Zola originally filed a complaint for trespass and to enjoin Reed from using a driveway on the Zola property. Reed was using this driveway for ingress and egress to the southern property, to Reed's southern property, but going over the Zola property. Reed, in defense, alleged that Reed had an implied easement to use this driveway. The trial court agreed and granted summary judgment in favor of Reed. Zola parties assert one assignment of error that the trial court improperly granted summary judgment. Now, like I said, this is about an implied easement. There are 4 elements to an implied easement. The first is severance of the unity of ownership of an estate, which I described previously. The second is before the separation takes place, the use, which gives rise to the easement, shall have been long continued and obvious or manifest to show that it was meant to be permanent. And the key word there is use. The third, the easement shall be reasonably necessary to the beneficial enjoyment of the land, to Reed's land. And the fourth, the servitude shall be continuous and distinguished from a temporary or occasional use. Now, the standard is that in order to prove this defense, Reed has to show that the implied easement meets all 4 elements by clear and convincing evidence. The parties stipulated to the first element, which is the severance of the unity. The parties also stipulated to the 4th element that Reed had used the driveway for ingress and egress from at least the time that Zola purchased the property in 2020. There is no stipulation to any time prior to Zola's purchase. Now, an implied easement is not enforceable against a bona fide purchaser, meaning Zola, for value who had no actual or constructive knowledge of the easement. So we'll look at the second element. And Reed did not present clear and convincing evidence of the second element of the use of the easement prior to the separation of the property that was long continued and obvious to Zola. Like I said, the parties only stipulated that Zola knew of Reed's use of the ingress and egress driveway after Zola purchased the property. Now, Reed did claim, as there was a hearing held on a preliminary injunction. So there was testimony taken in this case. And Reed did claim that the use of this driveway was long prior to Zola purchasing the property, and that there were others that used it also. For example, an airplane flying club that used this driveway. But the fact that the driveway exists is not constructive notice to Zola of Reed's use of the driveway prior to the purchase. Now, as I said, use is the main issue here. Now, the trial court said that the driveway exists, therefore Zola had notice prior to the purchase. But when you look at the second element, the main thing about it is that the use of the driveway. So that, in the testimony, the owner of Zola and the manager of the property, the tenant, testified that they knew the driveway was there. And they knew that that driveway was used for their property. They did not know that Reed was using the driveway to get to the southern property until after the purchase.
Counselor, what's left in the trial court right now?
What's left at the trial court at this point?
Yes.
There is another issue regarding a sewer line that is running from the southern property through the Zola property. Now that issue is not with regard to implied easement. That is an issue that the defense at this time is easement by necessity, but the court has not addressed that issue as they gave 54B language for us to come here to you to address this issue.
Thank you.
Now, as I said, there's at least a question of fact as whether Zola and the tenants knew of the use of the property, thereby defeating the second element with regard to summary judgment.
Is there a problem with the way the judge crafted its order, seeming to make findings of fact instead of applying a summary judgment standard? It seems like the judge ruled based on the facts that it was reasonably necessary, instead of saying, doing the burden shifting analysis.
You're correct, Your Honor. But that goes to the third element, and we do not believe that they have met that element either. That the court did weigh facts in this case because there was testimony taken. However, with regard to that third element, the reasonable necessity, the court relied upon a 8th District case, Mapes versus Smith, that in Mapes, they said that the court does not need to look at alternatives to the use of the driveway because why? We don't know. The 8th District didn't give us any background, no court cases that said that previously. And this court, as well as 2 other courts, have followed the Siskey versus Wentworth case from the Supreme Court that basically that the court has to look at the extent of the use, the character, and the surroundings of the property, and the relationship of the parts that were separated.
Right, and these are all fact-based analyses.
Yes.
So if there's contrary facts, and we're talking about summary judgment,
That's my point.
Where is that in the journal entry?
Your Honor, I don't believe it's in the journal entry. The court just basically said, we're following Mapes, but gave no reason for doing so. The court did not obviously address Siskey. There's another case from the 8th District, Shangri-La, Ohio, LLC. There's a case from the 4th District, Dunn versus Ransom, a case from this district, Vaccaro versus Borgion, which looked at reasonable alternatives. And in this case, there's a stipulation, or actually an admission by Mr. Reed, that a driveway could be built on his eastern property that could reach the southern property. So we have a question of fact as to what's reasonable here. So as I'm stating, with the second and third element, the appellee has failed to meet the burden for summary judgment because there is a question of fact remaining. And you can see from what the court did, the court was weighing those facts rather than applying the summary judgment standard.
And you're heading into your rebuttal time.
Thank you. I will stop here. Thank you.
Morning, Your Honors. May it please the court, Stephen Bozak on behalf of the appellee, Reed Salvage Corp. I want to start where Judge Lanzinger left off with the Rule 56 standard. I don't believe that the Rule 56 standard requires that there be no factual disputes between the parties. The question is really whether or not there is a genuine issue of material fact. And here, I think the trial court applied the Rule 56 standard. He cited it in his opinion. He then went on to apply the facts as he saw them presented. And I want to touch on, I think we can start with the reasonable necessity standard because I think that's the element that is most in dispute here as it relates to appellant's arguments.
Isn't it difficult though at summary judgment when you have a reasonable standard, like a reasonable man or reasonable necessity, to grant summary judgment if there are contrary facts? Isn't that usually left to the fact finder if there are contrary facts?
I think that would be the case if there were contrary facts here, but this is not. I think it's important here. The distinction here is that this is not a necessity easement. This is a prior use easement that applies a different standard. And here the question is whether or not the access point, that ingress and egress, is reasonably necessary. And here, what separates this case from some of the other cases that have come before both this court and around Ohio is that there are no alternative means here. The alternative means are theoretical.
Are they theoretical or are they expensive?
They're both. They're both. They don't exist at the time. And it's more than just being expensive, because here, what appellant leaves out of his, at least oral argument, is that the neighboring property that Reed Salvage owns, it is a salvage yard and a landfill. That means it is subject to a heavily regulated industry about who can access the salvage yard, when it can access it. There are state laws, and this is all in the summary judgment briefing, but there are state laws as to when a salvage yard can be open. They have to take measures related to security. There's fencing. There's a number of issues when you think about trying to build a new access point through a salvage yard, through a landfill, to access that back land. And if we were here talking about an easement by necessity, that's a question that we would be dealing with. But I don't think that that question needs to be answered by this court to apply the prior use easement. And I think it's important to point out that each of the cases cited by both parties, both the appellants and the appellee, in each of those cases, the appellate court upheld the finding that there was a prior use easement, regardless of how or if there were alternative means. So I'm thinking specifically of the Dunn case from the 4th District. In that case, there was two separate means of access, but the court looked at that alternative means and they said, it's too steep, it's too dangerous, it's reasonably necessary to have that access point.
Did they do that in the context of summary judgment?
Dunn was on summary judgment. And so that was the summary judgment order upholding the prior use easement. And here, I think it's important to also note that separate from Dunn and separate from Shangri-La out of the 8th District, that also had an alternative means where the court looked at both the easement by prior use and the alternative means, and they said, because of how difficult the alternative means were, the existing prior use easement was reasonably necessary. And Vaquero, I think, is another important case that's from this district. I believe Judge Sutton was in the concurrence. That is a case where there was a shared driveway, but the easement applied to the apron of the driveway, that you could not access a shared driveway without going over this apron. And so the neighboring property owner brought evidence that you could access the shared driveway without the apron, but the court still found that a prior use easement could apply because it was reasonably necessary due to how the traffic pattern was on the road as you access the shared driveway. And I think this is a starker example of those prior examples, because here, this driveway, as has been undisputed by the party, has existed for decades, has always been the means of access from that front land, now the Zola property, to the back land, which is now the Reed property.
You say that definitively, but wasn't that actually an issue of dispute?
I do not, I was just about to go there, Your Honor. I don't believe it's disputed, because the only evidence put forth by either party as to the prior use of that easement came from Craig Reed, who testified that he had used that land, used that driveway since he was a kid. He's 60 years old, 60 plus now. And you also had the testimony of the chairman of the RC club, who testified that they had built a RC landing strip. They do model planes, kind of the big remote control planes. They had built a airstrip on the back property in 2007, and they had been using that driveway since 2008. So 20, almost 15 plus years, they had used that driveway to access the backland.
But there was no express easement.
Correct.
So how were the Zolas to know that that driveway was being used by Reed?
I think that's a question of constructive notice, right? When you have a driveway and you have the testimony of Zola's owner, the owner of Zola, and also a manager, that they visited the property beforehand, that they saw the driveway. Their argument is not that they didn't know the driveway exists prior to the purchase. Their argument is that they did not see cars using it.
Or they didn't know what the driveway was used for.
And I understand that that is an argument, but it's difficult to imagine what use a driveway would be other than to transport vehicles and persons from one spot to another.
Which gets us back to Judge Lanzinger's point. That sounds like a jury issue.
I don't think that's the case, because in this case, I think you can rule on summary judgment as to whether or not a driveway that is the only means of access between one point and another, whether that, as a matter of law, provides constructive notice. And I think if you look at the totality of the facts that we have here, we have the driveway that's been in existence for decades. We have the appellant.
It's been in existence for decades, but it was one property when it was in existence, right? Being used.
Correct.
So, but the division is over that driveway.
I'm sorry, I'm not sure
So
if I
that the
understand.
actual part, when it's actually two different people's property, that's only been recently, right?
That dates back to 2018, yes. And that's a couple years before Zola purchases the property. I think it's important that we not confuse the elements of establishing a prior use easement and the elements of whether the defense, essentially, of bona fide purchaser. So by prior use, one of the elements, the second element, as appellant's counsel was highlighting, you have to show that the use giving rise to the easement was continuous and obvious. That's different than having to establish, or at least appellant's obligation to establish, that they were a bona fide purchaser. I think it's impossible. I think you would completely destroy the easement by prior use if you tried to argue that the new property owner has to have knowledge of the historic use of the driveway. That's not the standard, as I understand bona fide purchaser. It's whether or not the easement that existed at the time, there was actual or constructive notice of that easement.
And how was the constructive notice? That's what I keep getting at.
I think the existence of a driveway.
Just the existence of the driveway, not knowing how it's related to the other property or anything else.
I think what's important here is that we're not talking about many driveways. We're talking about one means of access. And it's a well-worn driveway. I think the court found that the testimony was clear, the aerial photographs, which I know the aerial photographs were also evidence in the Vaquero case, kind of showing the historic use of that driveway.
Well, again, back to facts. If the property is divided for two businesses, isn't it reasonable to think that one business might have bought the property that has the driveway and the other business would have to build a driveway
Well,
or a parking lot?
what's different here is that at the time that Zola had purchased the property, Reed Salvage already owned that back land. So Zola is purchasing the front portion. The back portion is owned by a different owner than they are purchasing from. So I think when you see a driveway that's going to someone else's property, I think that puts you on constructive notice that, hey, maybe I need to investigate this further. What is the use of that driveway? Why is it there? And that's why I think you can declare on a summary judgment motion that there is constructive knowledge when you have a driveway that's going to someone else's property. I think that puts the purchaser on notice that I need to investigate that further. And I think that's the standard. The bona fide purchaser standard is whether or not you have actual knowledge or whether or not there are knowledge of the factual circumstances that would make a reasonably prudent person investigate that further. And here I think we're not talking about pipes in the ground, right? We're talking about a plainly visible access point driveway to a different property. I think that puts a purchaser on notice that they need to investigate that further. Now I want to quickly, I think I've touched on this, but I just want to wrap that up. The second element, appellants have said that they essentially dispute the use of the property or the use of the easement prior to their purchase of the property. But again, that's the only evidence before the trial court was undisputed evidence via aerial images and testimony from both Craig Reed and the RC Club chairman that the use of the driveway had been continuous and obvious. And so there is a burden on appellants, even under summary judgment, that if there is evidence put forward in the motion for summary judgment, you have an obligation to rebut that evidence. And there was no rebuttal. And indeed, there really couldn't be any rebuttal because appellants were arguing that they're bona fide purchasers. So they can't now come up with an argument that, oh, the use of the property was different before they purchased. So I think the second element of the prior use easement, to the extent that there is a factual dispute, I don't think there's a genuine one. And I think the material facts establish the prior use easement. And I do think, I'll address a little bit about the Mapes decision. I understand that the trial court highlighted the Mapes decision, saying that I don't need to consider alternative means on a prior use easement. And while that's recognized in Mapes, I think that ignores what the trial court did right before he cites the Mapes, which is essentially acknowledge that the reasonableness of Reed Salvage's easement by prior use. He talks about the properties being landlocked. He talks about that there is currently no other access point aside from the easement itself. And so he talks about the difficulty and the challenges of creating a new means of access. And so even if, I don't think it's fair, even though the court cites to Mapes to say that it did not consider alternative means, even if this court doesn't want to join Mapes in that analysis.
When the court says it's landlocked, does it say it doesn't abut a road? Is that what it means?
It's landlocked in that there are no other.
So basically landlocked in this context means there's just not another driveway.
Correct, it has no other means of access
Not-
in and out of the
Not
property.
a road, it does abut a road.
It does not, no.
There's no road on that side.
No, that backland, the only means of access and I'll point the court to the summary judgment has some aerials that I think do a pretty good job of showing the various properties. But essentially, the Reed property that we're arguing over is a portion of the backland, and the Zola property is just north of that. And the Zola property is the only means of access to State Route 82. And so, yes, it's landlocked in that it has no other means of access to a road. So just to return to that point quickly, I think the trial court applied a proper analysis and highlighted sufficient facts to establish a reasonable necessity for this existing driveway. And I'll leave the court just with, this is the only means of access. It was the only means of access at the time. It's still the only means of access. I think with that, the court's decision should be affirmed, and the trial court properly rendered summary judgment here. Thank you.
You'll have your full 5 minutes for rebuttal.
Thank you, Your Honor. To address the reasonable necessity issue, we actually never really got there because the court granted summary judgment based upon MAPES that said there's no necessity to address a reasonable alternative. Now, what the facts that were presented were, Mr. Reed testified that a road could be built on his eastern property that could access the southern property, his southern property. Whether that's difficult or expensive, or we never really got there because the court, what I believe, actually misapplied MAPES because there's nothing backing that particular finding, especially when you have the other cases, including this court's case, that does address issues of reasonable necessity. Now, well, for example, Vaccaro, I believe, addressed an issue that it wasn't reasonable to grant the easement because of safety issues. Here we have the exact opposite when you look at the testimony that was presented, that the use of this driveway to access the southern property is actually a safety issue for the business invitees and employees of the Zola property and their tenants. So the court has to look at those facts, and it's still a factual issue with regard to the reasonable necessity. Number two, I think with the second element, you have to look at the Campbell versus Great Miami case with regard to what the knowledge is at the time of the purchase. And that's knowledge of the use, not the fact that there's a driveway that exists. Obviously, there's a driveway that exists to access the Zola property. If we don't know if someone's using that driveway to transverse the Zola property to get to the southern property, there's no constructive knowledge because there's a driveway there. If you look at the Campbell case, the Supreme Court said that the person who purchased the property had knowledge that there was a septic tank, that there were several manholes, that they opened one of the manholes and saw sewage in it. But that was not knowledge that the neighbor was using those pipes to get to the septic tank on the purchased property. In other words, there was no evidence that they knew that the neighbor was using the purchased property. We have the same situation here because there's evidence that these things existed, like the driveway. You still have to have constructive or actual knowledge of the use of the driveway. There is no evidence presented in this case that my clients knew that the driveway was being used. And the use is the main point there, not that the driveway exists. As a result, we believe that the trial court improperly granted summary judgment in this matter, and we're requesting that this court overrule the trial court and remand the case for further proceedings. Thank you.
Thank you both for your presentations today. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also the opinions are posted on the Ohio Supreme Court website. Thank you again.